Mungneeram, Bangur and Company were owners of a large tract land situated in the vicinity of Dhakuria Lakes of Calcutta. This company started a scheme for the development of the above land for residential purpose, and for this, they divided the entire area into plots and offered to sale. The plan of this company was to enter into agreement with different purchasers for sale of these plots and only accept a small amount of money as consideration by way of earnest money at the time of the agreement. Bijoy Krishna Roy, one of the purchaser, came into an agreement with Mungneeram, Bangur and Company on 5th August 1940. Date was fixed and sum of 101 rupees was paid as earnest money. On 30th November 1941, Sathyabrate Ghosh was made a nominee by Bijoy Krishna Roy. Before Satya became the nominee, on 12th November 1941, under Rule 29 of the Defence of India, the collector requisitioned a part of the land for military purposes. Another part of the land was requisitioned by the government on 20th December, and the third requisition of the rest of the land happened some time later. In November 1943, Mungneeram, Bangur and Company wrote a letter to Bijoy informing him about the requisitioning of the land and that there was no knowledge of how long the government would retain possession, and due to this, they were unable to construct the proposed constructions. So, the company decided to treat this agreement to sale as cancelled and gave Bijoy the option of taking back the money within 1 month of the receipt of the letter. There was an alternative offer made. The purchaser can refuse to treat it as cancelled if he pays the balance of the consideration money and takes the land in the condition which it existed at that time with full construction after the termination of the war as per the agreement. On 18th August 1946, Satya brought this suit against the defendant company on the grounds that the contract between first and second defendant still existed, that he was entitled to get a convenience executed and registered by the defendant on payment of consideration money. The trial court overruled all the defendant pleas and supported in favor of the plaintiff Satya. The defendant company filed an appeal at the Court of District Judge, which was dismissed, and the defendant company further approached the Calcutta High Court. Then, the plaintiff Satya filed an appeal to the Supreme Court. The only question was whether the contract was frustrated within the meaning of the provision of Section 56 of the Indian Contract Act, and the execution is impossible. The Lordship compared the Section 56 of the Indian Contract Act, compared them with the English law, and observed that doctrine of frustration is really a part of the law of discharge of contract by reason of supervening of impossibility of the act to be done, and hence Section 56 of the Indian Contract Act applies only to physical impossibility. The court held that the Indian Contract Act deals with a particular subject and it is not permissible to import the principle of English law. Principles of law laid down. In order that Section 56 of the Indian Contract Act, that the act should have become impossible, that the impossibility should be the reason which promiser could not prevent, that the impossibility should not be self-induced by the promiser or due to his negligence. A contract to do an act which after the contract is made becomes impossible by reason of some event which the promiser could not prevent is unlawful and becomes void. In this case, no time is fixed for the performance. Thus, the delay is due to the requisition of the government. So, it does not make the contract impossible.